One can introduce themselves on the conference table for the benefit of the court reporter. My name is Nikki Eke. I'm the attorney for the Procurement Appeals Board.
My name is Scott Potter. I'm director of Nashville's Metro Water Services.
I'm Diane Lance. I'm the director of Metro's Office of Family Safety.
Brady Rich, Deputy Director of Metro Codes.
Gerald Smith, Director of General Services.
Michael Catone here today on behalf of CHS.
John Cooper with Holland and Knight on behalf of CHS.
Stacia Daigle with Adams and Reese on behalf of Vital Corps.
Rocky King from Adams and Reese, also on behalf of Vital Corps.
Macy Amos here representing the purchasing agent.
Dennis Rowland, Chief Procurement Officer and Purchasing Agent for Metro Nashville.
Sandra Walker, Metro Procurement.
Annabella Gelmetti, Executive Assistant to the Director of Finance.
My name is Stephanie Gravert Spitzer. I'm here as the timekeeper.
Announcement of item number 1, announcement of appeal process. Pursuant to the provisions of section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Procurement Appeals Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of certiorari. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. Item number 2 on the agenda, we are going to conduct an election of the chair pro tem. Are there any nominations from the board members?
I nominate Scott Potter.
Okay. All in favor? Raise aye or raise your hands. Okay, it's Mr. Porter is now the chair, and I'll turn it over to Mr. Porter.
Okay, thank you, Nikki. There's a public comment period that's still on the agenda, but we had no one sign up, so there'll be no comments from the public. The Procurement Appeals Board is here to consider RFQ number 379372, Inmate Medical, Dental, and Behavioral Health Care Services. Before we get started with the agenda, attorney to the board, Nikki Eke, may have additional announcements that she would like to make, and if so, please proceed, Nikki.
Sure. Before the Procurement Appeals Board today is the appeal of CHS Tennessee LLC regarding the intent to award issued to Vital Corps Health Strategies LLC with respect to RFQ number 379372 for inmate medical, dental, and behavioral health services. After a hearing, the purchasing agent dismissed the protest filed by CHS. CHS has appealed the purchasing agent's determination. The role of the board today is to determine whether the award was done in accordance with applicable law and the terms and conditions of the solicitation. Applicable law includes the Constitution, statutes, procurement code, and procurement regulation. The board reviews the record and relevant information to determine whether the evidence establishes that the award was in accordance with applicable law and the terms and conditions of the solicitation. If the board determines that the award was in accordance with applicable law and the terms and conditions of the solicitation, the board can uphold the decision of the purchasing agent. If the board determines that the award was not in accordance with applicable law or the terms and conditions of the solicitation, the board can modify the decision of the purchasing agent and remand the matter to the purchasing agent with further directions. There's a procedure for the appeal, which does everyone have that? That sets out the chronology and time presentations. So I'll turn it up to the chair. Over to the chair.
Thank you. To get into the record, the members of the board, they have introduced themselves, but I want to read the list again. Scott Potter, Gerald Smith, Diane Lance, and Brady Rich our members of the board. I'm going to review how we're going to conduct business today to make sure everybody understands. First, there'll be a presentation by the purchasing agent that has a 30-minute limit. Then there's a presentation by the appealing party with a 30-minute limit. Any interested party presentations will follow that 20 minutes limit per party. We'll have a 5-minute break. Then we'll have a second presentation by the purchasing agent, a second presentation by the appealing party. Another break is scheduled at that point, and then discussion and deliberation by the appeals board. So now we will begin the agenda. As brief, the purchasing agent will provide a presentation. A timer will begin for 30 minutes once that presentation begins. Will the purchasing agent please introduce himself and proceed with the presentation?
Thank you, Chair Potter. My name is Dennis Rowland, and I'm the Chief Procurement Officer and Purchasing Agent for the Metropolitan Government of Nashville and Davidson County. I'd like to thank you all for your time today in reviewing solicitation number 379-372, Inmate Medical, Dental, and Behavioral Health Services. Coming from the private sector, I appreciate the checks and balances within Metro's processes to ensure the highest degree of integrity for our citizens. This review is an important part of the process and will be handled accordingly. Approximately 18 months ago, when I was exploring the possibility of accepting the purchasing agent position, my number one concern was related to Metro procurement processes, since government procurement is drastically different than my previous experience in the automotive industry. After several reviews and discussions, I was very impressed with what Metro Nashville already had in place. I make this point for a reason. On any given day, we have around 100 to 150 solicitations. Since my start date on February 26, 2024, this is the first appeal in my tenure. If our processes were not executed properly, Metro Nashville would struggle to operate efficiently as a government, given the protest and appeals process. In addition to this fact, our procurement team was just recognized by the National Institute of Government Procurement with the Quality Public Procurement Department accreditation, in which we were named the 36th entity to receive this honor in all of U.S. and Canada. To receive this accreditation, our submission included 125 in-depth questions related to our process. With this accreditation, I can proudly say that we are one of the top government procurement agencies in the country. One key point that I would like to make before I get into the project summary is that every procurement solicitation we have is different. Our procurement division supports 51 departments who all have unique requirements. The strategy for each department is different. The timing for each solicitation is different. Our goal is always to strive, Our goal is always to strive to optimize the best value for Metro Nashville and Davidson County citizens. For procurement, we can't have a cookie-cutter approach to achieve this. Fortunately, our regulations and codes accommodate the need for us to be flexible during the process. Now I will begin the actual appeal. Before you today is the appeal of CHS Tennessee LLC regarding the intent to award issue to Vital Core Health Strategies with respect to RFQ, RFQ number 379372 for inmate medical, dental, and behavioral health service. After a protest hearing, I dismissed the protest filed by CHS. CHS then filed an appeal of my decision to this Procurement Appeals Board. At this time, I would like to give the Appeals Board a high-level project summary of the solicitation. The solicitation was published on September 25, 2024. A pre-offer meeting was held for this solicitation on Tuesday, October 8, 2024 at 11 a.m. Central Standard Time. A first site visit was held on Wednesday, October 9, 2024 at 10 a.m. The site location visits were the Downtown Detention Center, Behavioral Care Center. Then a second site visit was also performed on the same day, which covered Correctional Development Center Female, Maximum Correctional Facility. The question deadline was Wednesday, October 16, 2024. Please note a key point regarding this timeline is that CHS had time to ask any and all questions related to the solicitation. CHS also had the opportunity to protest the solicitation. During the process, there were a total of 8 amendments. Amendment number 4 and amendment number 8 being the critical amendments related to this appeal. The amendment number 4 posted the pre-offer meeting, sign-in sheets, PowerPoint presentation, on-site visit sign-in sheets, and updated the evaluation criteria and staffing matrix. It also increased the page numbers for the project approach and process from 10 to 15 pages. The amendment number 8 posted online discussion questions and answers, updated the scope of work, cost spreadsheet, and evaluation criteria. There were 6 proposals received on the closing date of December 17, 2024. 7 evaluation meetings were held, January 29th, February 2nd, February 6th, February 12th, February 13th, February 26th of 2025. The intent to award was issued on 3/14 of 2025. I will now move on to the points of protest. Point of protest number 1, applying a strict and low page limit on submissions deprived evaluators of information necessary to evaluate the proposals. The page limits were established in the solicitation as allowed by R4.12.040.05 form of proposal. The matter in which proposals are to be submitted, including any forms for that purpose, may be designated as part of the request for proposals. This point of protest is relative to the solicitation, not the award. CHS failed to protest the page limits within the allowed time frame. This made my decision to reject this protest point and dismiss without further consideration. R4.36.010 of the regulation places a 10-day limit on protest relative to the point in time when the information given rise thereto is available. This means that the time to protest the content of the solicitation, including page limits, was on or before October 5th, 2024 at the earliest, or on or before December 16th, 2024 at the latest. The solicitation was initially published on or about September 25th, 2024, and it was amended into final form on or about December 6th, 2024. We now move on to point of protest number 2. The evaluation process violated the terms of the RFP according to CHS. Per R4.12.030.09.1, Metro is allowed to amend its solicitation so long as it follows the rules outlined in the regulations. R4.12.030.09.1 form, amendments to invitations of bids shall be identified as such and shall require that the bidder acknowledge receipt of all amendments issued. The amendments shall reference the portions of the invitation to bid it amends. R4.12.030.09.2 distribution, amendments shall be sent to all prospective bidders known to have received an invitation to bid. Acknowledgement of receipt shall be in accordance with subsection R4.12.030.03.4 of this section. And please note, these sections say bid and bidder because R4.12.040.09 amendments to request specifies that amendments to requests proposals may be in accordance with section R4.12.030.9 invitations to bid prior to the submission of proposal. The protesting party asserts that Metro did not follow the terms of the RFP because the awarded supplier was allowed to submit information on project approach beyond the 15-page limit. Our records show that Metro made this clear in response to online questions published as part of Amendment 8, that offers could submit staffing plans that would not count against their project approach page limit. It is important to validate in all cases that all suppliers receive the same information at the same time. Our records indicate that protesting party representative Dana Bell acknowledged receiving Amendment Number 4 on October 11th and Amendment Number 8 on December 6th in the Metro iSupplier system. R4.12.030.09.2 distribution detailed above. This is important because the regulations seek to ensure that the amendment process is fair and that all prospective offers have access to the same information, which is why the acknowledgement is so salient in this case. The vendor acknowledges receipt as required. In fact, CHS had the same opportunity, but asserts the awarded supplier's staffing plan constitutes an additional project narrative because it included an explanation of staffing. An explanation of staffing is a reasonable part of any staffing plan. Nothing prohibited the protesting party from providing a similar explanation of staffing as part of their supplemental staffing plan. We will now move on to point of protest number 3. The scoring process was arbitrary. R4.12.040.16 requires that Metro make a written determination showing the basis on which the award was determined most advantageous. This was done via consensus scoring, as is the standard for all Metro solicitations. That justification with evaluator comments was published and is available in the public domain. I think at this point it's very important to explain the consensus scoring process. Consensus scoring means just that. There is no scorecard. There are no individual notes from evaluators. Instead, the evaluation committee appointed by the purchasing agent and comprised of subject matter experts are provided all responsive proposals in advance. They are asked by the procurement officer to review these proposals and come prepared to discuss with the group at the evaluation committee. Why do we do this? Because it is our job to achieve the best result for Metro as a whole. Take this contract, for instance. Inmate health care is not the exclusive prerogative of one department. It involves both the sheriff and the health department. Evaluators from both entities were on the evaluation committee. Those from the sheriff office have one perspective. Those from the health department have a different perspective. We use consensus scoring because both perspectives are necessary. If evaluations use scorecards or assign their own scores in silos, we would end up with a contract that met one side of needs but not necessarily the other. With consensus scoring, all parties come together, listen to each other, and achieve a result that is balanced and in the best interest of Metro as a whole. The evaluation committee approved by the purchasing agent will evaluate the technical and past experience sections of the proposal, while the purchasing agent designee will evaluate the price and cost. The committee members and advisors are required to sign a conflict of interest non-disclosure statement to ensure impartiality and confidentiality. The evaluation process involves considering technical, functional, and services features of the proposal, as well as the offer's experience and capability. The procurement officer guides the evaluation team reviews using pre-established standards and procedures, including the order of the proposal evaluations. To ensure fairness and consistency and effective evaluation, the committee thoroughly reviews all proposals except for cost prior to the committee discussing the evaluation. Evaluations will be based upon the evaluation criteria published in the solicitation. The procurement specialist guides the evaluation process, empowering evaluators to determine appropriate scoring through discussion of merits and proposed technical expertise and resolving any differences of perspective regarding such. Per R4.12.040.13.2, the purchasing agent may appoint individuals to an evaluation committee who possess expertise in the subject matter of the procurement to provide award recommendations to the purchasing agent. In this case, the evaluation team members for this solicitation are some of the most distinguished individuals within Metro from both the health and sheriff's department. In total, there's over 100 years of experience on this team, so the scoring of offers is the prerogative of the subject matter experts on the evaluation committee. It is not for the protesting party to substitute their judgment for that of the evaluators, nor is subjective scoring an appropriate basis for protest. We will move on to point of protest number 4. Critical factors in how the contract will be performed were not considered. Page 7 of the RFQ references a MOU between the awarded provider and a number of entities. The protesting party has interpreted this as requiring any responsive offer to use the services of one named entity, the Mental Health Cooperative. This is a fallacy on the part of CHS. That section of the RFQ is intended to do 2 things. First, it is intended to provide potential officers with information on how the contract is currently performed. The named entities all have a current role in providing inmate health care. If the awarded provider chooses to go a different direction, then an MOU will be necessary to manage the transition of services. VitalCore has confirmed multiple times that they will execute the required MOU to transfer services from Mental Health Cooperative to an in-house provider. Second, it is intended to establish the precedent that these MOUs will be updated regularly so that the sheriff and the Department of Health are aware of which entities are involved and how those relationships are managed. The RFP specifically states that the MOUs may be updated as required, but must be at least updated annually. There is nothing here to suggest that the use of any of these providers is a requirement. The RFP no more suggests that they have to use Vanderbilt Health to the exclusion of the other providers in the area. It is worth noting that for all the talk from CHS about Mental Health Cooperative and the role they played in their offer, CHS did not take the time to list Mental Health Cooperative as on their subcontractor form in our response. We will now move on to point of protest number 5. VitalCore should have been disqualified because it failed to comply with the RFP terms. The protesting party asserts that Metro did not follow the terms of the RFP because the awarded supplier was allowed to submit information on project approach beyond the 15-page limit. Our records show that Metro made clear in the response to online questions published as part of Amendment 8 that offers could submit staffing plans that would not count against their project approach page limit. It is important to validate in all cases that all suppliers receive the same information at the same time. Our records indicate that protesting party representative Dana Bell acknowledged receiving Amendment 4 on October 11th, 2024, and Amendment 8 on December 6, 2024 from the Metro iSupplier system. The fact is CHS had the same opportunity but asserts the awarded supplier's staffing plan constitutes an additional project narrative because it included explanation of staffing. An explanation of staffing is a reasonable part of any staffing plan. Nothing prohibited the protesting party from providing a similar explanation of staffing as part of their supplemental staffing plan. We will now move on to point of protest number 6. VitalCore proposal was incorrectly scored. R4.12.040.16 requires that Metro make a written determination showing the basis on which the award was determined most advantageous. This was done via consensus scoring as the standard for all Metro solicitations. That justification with evaluator comments was published and is available in the public domain. The evaluation team members for this solicitation are very experienced individuals within Metro from both the Health and Sheriff's Department. The scoring of offers is the prerogative of the subject matter experts on the evaluation committee. I've made this clear regarding the point on the staffing plan inclusion. It is not for the protesting party to substitute their judgment for that of the subject matter experts on the evaluation committee. The evaluation team that was approved by the purchasing agent included the following individuals: Dr. Joanna Shaw Kaikai, Interim Director of Health and Chief Medical Officer; Dr. Kenton Dodd, Civil Service Medical Examiner, Medical Doctor; Lauren Nunn, Health Manager 2; Jim Diamond, Bureau Director; John Hudson, Chief Deputy Sheriff; and Ruby Joyner, Chief of Corrections. All of these individuals are more than qualified to evaluate these offers. CAS may not argue with their evaluation, but that is irrelevant. They are the user departments of the service. They are the subject matter experts, and we should defer to their expertise and not grievances of a non-awarded supplier. We will now move on to point of protest number 7. Metro improperly asked questions of Vital Corps during the solicitation process. There were 4 clarifying questions that were asked of Vital Corps. Question number 1, does the contractor agree to provide services for on-site and specialty care without billing private insurance or Medicare, Medicaid? Question number 2, for emergency responses, will the expectation be for medical staff to provide basic life support in addition to first aid or first aid only? Question number 3, who will provide medical health services, the contractor or a subcontractor? And question number 4, how will care be provided for patients in restricted housing units that are not able to come to the medical clinic? The procurement regulations dictate the acceptability of clarifying questions. R4.12.040.14.2 of the regulations state purposes of discussion. Discussions are held to promote an understanding of Metro's requirements and the offer's proposal, and B, facilitate arriving at a contract that will be most advantageous to Metro, taking into consideration price and other evaluation factors set forth in the request for proposal. The protesting party argued during the administrative hearing, that it was improper for Metro to ask questions of the awarded supplier during the evaluation process. R4.12.040.14.2 of the regulations allows for discussions that promote the understanding of the offeror's proposal. The questions asked by Metro meet this standard. They did not result in any changes to the solicitation or constitute in any way a modification or addition to the awarded supplier's proposal, rather clarified information already expressed in some way in the offeror's proposal. Further, the questions asked by Metro all pertain to project approach and process. Even if the protesting party received full marks in this category, it would only move their total score from 83.66 to 89.66. This would be insufficient to overcome the awarded supplier's final score of 92.03. Simply put, the CHS offer was deficient. It seemed to be a copy-paste job that consisted primarily of screenshots. The committee felt and still feels that the base offer was so deficient that there was not sufficient basis for asking follow-up questions. It is not that Metro failed to provide equal treatment, it is that CHS failed to provide an offer that was sufficient to meet Metro's needs. In closing, when this protest was filed, Metro Procurement performed a thorough review and found all points contained therein to be either not timely filed or without merit. To put it simply, this protest is frivolous. As the Chief Procurement Officer, our goal is to have very strong competition in all solicitations. My only regret is that CHS would have put as much focus into their proposal as they have the protest and appeals process. What the committee must decide today is whether they trust the judgment of Metro's evaluation committee comprised of practitioners and subject matter experts, or the judgment of the legal team representing a disgruntled offeror. Thank you so much for your time. That is the end of my presentation.
Thank you. So next item on the agenda is the appealing party will make their presentation. Please be reminded there's a 30-minute limit for the presentation, and the 30-minute timer will begin when the presentation begins. For the record, would the people representing the appealing party please reintroduce themselves to the board?
Good morning. Again, I'm John Cooper with the law firm Holland & Knight. With me is my partner, Michael Catone. We're here representing CHS and the operator Yes Care, who finished second in the evaluation of this contract. Again, thank you for making yourselves available. As you know, this board does not meet often, and that's a good thing. I would agree that this is an outstanding procurement department. I was here for 20 years, worked with them frequently. But I also realized in those 20 years that sometimes Metro can make a mistake, and that's okay. And it's all right to acknowledge that and fix it. So again, you've been through the record of how we got to where we are, but our appeal to the board was timely filed on May 1st, and it does meet all the requirements of section 4.36.120 of the Metro Code. I would ask that our May 1st appeal letter and the exhibits attached thereto be made part of the record. With us are representatives.
Mr. 1 second, is that permissible?
Yes, the procurement record the record of this appeal will include the procurement materials and all materials submitted by the appellant and interested parties. It will all be part of the record, all the documentation.
With us are representatives from CHS and YesCare to answer any questions that you may have. But I would like for Bill Carr, who is the COO of YesCare, would like to briefly address the board.
Mr. Carr, if you would, please introduce yourself to the members of the board.
Good morning. I'm Bill Carr. I'm the Chief Operating Officer for YesCare. Thank you. For those of you not familiar with us, we are a healthcare company providing care to about 40,000 incarcerated individuals across the country. We are a Tennessee-based company. We're headquartered in nearby Brentwood. And I really do appreciate the opportunity to spend just a few minutes with you. Great respect for the process you're going through. It's not an easy process. I probably have been on your side of the table more than I've been on this side of the table. Previously served as Chief Legal Counsel for the Indiana Department of Correction, having been involved with multiple statewide solicitations, including the state's first foray into privatized correctional health care. I was Assistant Secretary of Reentry for the state of Florida, where we were constantly procuring dozens of contracts throughout the state for reentry services, educational programs, substance abuse programs. So I'm very familiar. Ironically, about 10 or 15% of those solicitations would end up in a protest. So I can commiserate with where you're sitting and completely understand that. The task in front of you is not easy. The risk to the county are so great that I think the decision is actually quite simple. Operationally, we're talking about the provision of health care for 2,000 individuals at the Davidson County Jail. They enter that jail with a much higher rate of suicide ideation, with mental health issues, with substance abuse disorders, far greater than what the general public have. Far greater. They're likely 4 to 5 times more likely to have communicable diseases such as HIV, such as Hep C, such as tuberculosis. They often come to your jail in pretty fragile conditions, likely not having access to health care for an extended period of time. They literally can put a significant portion of your jail population at risk. To fully understand and vet healthcare providers under these scenarios is and should be a tremendous undertaking to make sure the decision is right. And with all due respect to the process that was used, I'm not sure that anyone responding to the 67-page RFP could provide an adequate description of their scope of services in 15 pages, especially the commonalities, the realities of dealing with the Davidson County Jail. You'd probably want to make sure that those companies are sufficiently equipped to handle 20,000 intakes a year, that they have processes in place to deal with patients that come there every single day going through detox, that they have protocols in place to make sure they're identifying those that have suicide ideation and mental health issues to help prevent or at least limit the opportunity for self-harm. That you'd probably want to know they understand what a company's philosophy and approach is in developing medication-assisted treatment for those going through opioid use disorders. And I'm just scratching the surface. I really am. You probably want to understand in very detailed, with great detail what that transition plan is from the time a contract is awarded to When a start date happens, you probably want to know what the company's philosophies are for attracting talent to this contract and make sure that the talent stays in place to deliver care. And there is going to be a change in an electronic health care record as a part of this process. That's a complex process. You want to make sure that that team you're evaluating has the depth, the knowledge, the know-how to handle a pretty significant IT project. Last, I would say you'd probably want to evaluate some of their existing clients to see how things are going in other jurisdictions. A doctor's not just a doctor, a healthcare provider is not just a healthcare provider. Pretty important to know with whom you're dealing with going forward. To not capture all of the above, or at least some of it, I would humbly suggest to you is a terrific gamble. And maybe you got it right. Maybe you got it right. But I would suggest to you that it really is the equivalent of awarding an Oscar for the motion picture of the year based on a 60-second trailer. And we happen to believe that in terms of providing care to 2,000 individuals on any given day, a more substantive review of those process and evaluation of those teams is likely warranted. God forbid if it was one of us, one of our loved ones entering that jail, but if that were the case, we would all probably want to know that the processes were adopted to make the best evaluation possible for the selection of a healthcare provider. The risk of bad outcomes, costly litigation, horrific headlines are all too great not to have a significant, robust system to evaluate all of those who are interested in the provision of this. And I would suggest to you that there are 2,000 people sitting in the Davidson County Jail depending on you to ensure those kind of processes are in place. Greatly appreciate you letting me have a few minutes of your time this morning. Thank you.
Thanks, Bill. Again, we don't believe there was any malintent, ill will. We just think that a mistake was made, and I'm going to walk you through why we believe that is the case. This appeal is about ensuring fairness, and that's what I'm going to go through. So I'd like to start with the contracting question. So this is a $150 million contract.
Could you tell us what page you're on in your presentation? Because we can't see it. We have it in
Oh,
front of us.
I'm sorry. It's I will tell you each slide. This is number 4.
Okay.
Slide 4 now.
All right, so we're not going to be able to face you and listen.
Okay, I will tell you as I'm changing
Okay,
slides.
let's do that. So just tell us what page you're on. That way we can face you as you're making the
Got it.
presentation.
Okay, this is slide 4. Again, this is a $150 million contract, which is one of Metro's largest to address both the physical and mental health needs of Metro's inmate population. This is a critical life and death contract. This is not a commodity. We're not buying widgets. And so the contract itself warrants a full vetting to ensure that the contractor that's selected can adequately provide those services. Choosing the wrong contractor could result in serious risk to Metro. So there is both reputational and financial, as well as healthcare risks to the inmates. On to slide 5. So I'd like to start with is that right? There we go. I'd like to start with the purposes of the procurement code as specified in the code. 3 primary purposes. First, to provide for increased public confidence in the procedures followed in public procurement. Second, to ensure fair and equitable treatment of all persons who deal with the Metro procurement system. And 3, to provide safeguards for the maintenance of a procurement system of quality and integrity. We submit that these purposes were not fulfilled in this particular procurement, which I will now move to the arguments why. On to slide 6. Let me start off by saying we are not challenging the page limitation. We knew that was a limitation. We accepted it. So the purchasing agent is interpreting our arguments as challenging the page limitation itself, which we are not, and I'll explain why, but I just want to say that on the front end. So the primary reasons are as follows why we are challenging this. The only identified scoring weaknesses for CHS in the intent to award, as you can see, there's a little narrative of strengths and weaknesses. The only weaknesses for CHS were related to lack of detail and vagueness. Yet Metro did not ask any follow-up questions of CHS, and most importantly, did not hold any oral interviews for this solicitation. Metro did ask the winning bidder VitalCore, and only VitalCore, follow-up questions and allowed them to respond with additional detail regarding their proposal without extending the same opportunity. And third, the requirement in the RFQ that bidders agree to enter into an MOU with Mental Health Cooperative caused confusion and led CHS to submit a higher cost bid. On to slide 7. So our first primary argument is that awarding a $150 million contract for inmate health care based upon a 15-page response alone is arbitrary. Not that the 15 pages was improper or that limitation, but only basing the award on that submittal we believe is arbitrary. We also believe that CHS was unfairly prejudiced by Metro's failure to ask follow-up questions or hold oral interviews. Again, over half the weaknesses identified for all bidders related to lack of information or vagueness, and the 4 weaknesses listed for CHS were clearly tied to the evaluators not having enough information. I'll list those weaknesses. Project management methodology lacks specific detail. Comprehensive plan lacks specific detail. Team sub-level knowledge and project experience in the provision of services related to the project lacks specific detail. Response to company licensing violations was vague. Failed to provide defined responsibilities for sub-level. On to, slide 8. So again, we knew the 15-page limit was in place. We knew it was going to pose a challenge on the front end, but Metro expressly reserved the right to reserve the ability to ask follow-up questions and, more importantly, to hold oral interviews. Given the importance and scope of the contract involved, CHS had no reason to think that Metro would not have follow-up questions or hold oral interviews. They likely would not have even submitted a proposal if they had known that was not going to be the case. They were prepared to and anticipated providing additional information about the company and its proposal during the follow-up question process and oral interviews. As an aside, I would note that the specifications portion of the RFQ that they were responding to was 25 pages, yet the plan responses were limited to 15 pages. So that's what the award was based on alone. Again, we're not challenging the concept of the page limit. We understand the reasoning behind limitations. We just are saying that without an oral interview or follow-up questions, any page limitation you're going to impose has to be sufficient to allow evaluators to fully understand and make an informed decision, and we don't believe that could have happened here. Again, absent follow-up questions and oral interviews, it's impossible to provide the required level of detail to make an informed decision about a plan for inmate health care in just 15 pages. Evidence of this can be gleaned from the prior 2 contracts for these services that were issued 5 and 10 years ago, both of which had proposals well over 100 pages. There have also been other Metro RFQs around the same time that did not have such a strict limit. One of those was an RFQ for a half-mile sidewalk, engineering for half-a-mile sidewalk that had a limit of 80 pages. So objectively, 15 pages alone is simply not enough information upon which to base an award of this size. On to slide 9. While not mandatory, oral presentations are recognized as a best practice for procuring complex governmental services. In fact, state law expressly contemplates it. TCA section 12-3-1207 provides that, quote, interviews, presentations, demonstrations, and discussions, either oral or in writing or both, may be conducted for clarification to assure full understanding of and responsiveness to the solicitation requirements, unquote. Further, section 5.11.6 of the State of Tennessee Procurement Procedures Manual specifically addresses the importance of oral presentations as a way to further assess a respondent's ability to deliver the proposed good or service that may not have been presented accurately or precisely in the written response, and to evaluate the respondent's key personnel who will be primarily responsible for performing the contracted services. When I was with Metro, I was involved in several complicated procurements, serving on a review panel for services. This included Metro's legislative, voting, and document management systems. And for me personally, the in-person interviews were critical to informing my decision about which contractor to choose. Metro is currently holding procurements that do have interviews. For example, there was a recent procurement of tablet computers for inmates. These are the little tablets that the inmates are given upon arrest, I assume. And interviews were held for that solicitation to determine which contractor should be selected to provide the tablet computers. But there was no interviews for providing health care to those inmates, which we think is just fundamentally wrong. And you know, in some cases, failing to hold oral interviews can make the procurement process arbitrary, and we believe that's what happened here. Basing this decision, again, just on 15 pages alone without these follow-up interviews or questions is arbitrary. It's very important to note that CHS did not know that they would not have an opportunity to provide more clarifying information or oral presentations until after the intent to award was issued. So there was no indication before that Metro would not be following that process. On to slide 10. We had submitted a public records request to Metro as part of the protest, and that's when we learned that Metro did ask Vital Corps and only Vital Corps follow-up questions, which resulted in a submission of additional pages in excess of the strict page limitation. Now, I understand the purchasing agent is saying, well, those were just clarifying questions, and the information provided was related to staffing plan. But if you look at the questions closely that were posed to Vital Corps, which were read, they're all related to the provision of services. I'll read them again. Does the contractor agree to provide services for off-site and specialty care without billing private insurance or Medicare, Medicaid? Second, for emergency responses, will the expectation be for medical staff to provide basic life support in addition to first aid or first aid only? Third, who will provide mental health services, the contractor or a subcontractor? And fourth, how will care be provided for patients in restrictive housing units that are not able to come to the medical clinic? If you move on to slide 11. Again, the purchasing agent argues that these are simply clarification questions and that they did not impact final score. But we will never know this because CHS was not asked to provide clarifying information for anything, even though it was docked in its the award for being vague. So had CHS been asked to clarify some of the items that were identified as vague, it could have certainly impacted the overall score. And again, a close examination of those questions I just read shows that 3 of the 4 pertain to how care will be performed and by whom. Further, the answers submitted by Vital Corps, which are included in your information, were related to qualifications and expertise, not just a staffing plan. We submit that this is a violation of section 4.12.040F of the Procurement Code, which provides that offerors shall be provided fair and equal treatment with respect to any opportunity for discussion and revision of proposals. Had CHS been asked similar questions, it would have provided information that could have resulted in the review panel identifying fewer weaknesses in the CHS proposal. The bottom line is that Vital Core was provided the opportunity to provide additional information, and CHS was not, which on its face we submit as unfair and arbitrary. On to page 12. Next, regarding scoring, we understand that this was consensus scoring. Our argument is that the notice of intent to award provided very little information about how the proposals were scored other than based on price. We know that scoring sheets are not required. We're not arguing that, but we're saying basing the score on the listed strengths and weaknesses without any backup information makes it impossible for the public to determine if the math was even correct in the scoring. On to slide 13. I'd like to spend a little bit of time talking about the Mental Health Cooperative. Again, as was noted, Mental Health Cooperative is the existing contracted provider of mental health services at the Behavioral Health Center, which is the mental health section at the jail. During CHS's due diligence in deciding whether to pursue this contract, they heard from both Sheriff's Office and Health Department representatives that continuation of Mental Health Cooperative as a subcontracted provider is critical to the success of the behavioral care program. Understanding this importance, CHS included the Mental Health Cooperative as a subcontractor, which accounted for $8 million of CHS's total bid amount. The purchasing agent said that they were not listed as a subcontractor, but if you look on page 4 of the project approach section, there is a statement about partnering with Mental Health Cooperative to deliver behavioral health care. So if CHS had decided to perform this work in-house, their bid would have been $8 million less, which would have made them a lower bidder than Vital Core. Again, as was noted, the RFQ specifically required that bidders enter into an MOU with the Mental Health Cooperative. Now, the purchasing agent states that the MOU is required because they're the existing provider and they would need to facilitate the transition of services to an in-house provider. But frankly, in context, this doesn't make any sense. The RFQ also required an MOU with Metro EMS. Does that mean that EMS services are being transitioned to Vital Core? Obviously not. So the only reason objectively that you could see for including that is that Metro wanted Mental Health Cooperative to remain the provider for these services. And from the RFQ language itself, CHS, you can see from its proposal, reasonably believed that including the Mental Health Cooperative was an integral part of the contract, and it resulted in an $8 million higher proposal. On to slide 14. In conclusion, we submit that the RFQ selection process here was unfair, arbitrary, inconsistent with the fundamental procurement regulations purposes, which I read, and unsupported by material evidence, which under Tennessee law makes the award unlawful. When an intent to award a contract violates the law, the procurement process must be restarted. We therefore submit that it's the Procurement Appeals Board's duty and obligation to cancel the intent to award to Vital Core and rebid the contract. We fully recognize the administrative difficulties this poses, but we believe that given what's at stake, it is the right thing to do. Again, we have YesCare officials here in attendance who can answer any technical questions you may have about the proposal. Thank you.
Thank you, Mr. Cooper. Now on the agenda is a interested party presentation. I now ask the individuals who will be presenting on behalf of the appealing party to introduce themselves. Please be reminded there's a 20-minute limit to the presentation. Are there any parties present who wish to provide a presentation?
Yes, Rocky King on behalf of Vital Core. We're handing out our presentation right now. We'll start here in 1 second.
I want to remind the interested party that your presentation is limited to 20 minutes instead of 30, just to make sure that you recognize that.
I do, and thank you. First off, my name is Rocky King on behalf of Vital Core. Thank you for your time today. We're asking you to affirm the purchasing agent's decision and allow the intended awardee, Vital Core, to assume this contract. As we're going to discuss today, the purchasing agent followed all applicable law and the rules of the procurement when making the determination that Vital Core should receive this award, and then rejecting the 7 enumerated protest grounds that CHS brought to him originally. And this body should do the same today. I'm not going to go through a lot of the background, but some of the salient facts, if we'll go to the second page, is that there were 6 respondents to this request for proposal and quote. And I think that's important because the evaluation committee had a lot of information to review here. This was also the 3rd time that this contract was procured of recent, and the actual incumbent was one of the submissions. So we have context. We have information that grounds the evaluation. This is not the first time that Metro is procuring these respective services. And in fact, several entities submitted responses outlining how they would provide these services. If we'll go to our next page, Metro set up the rules of procurement here, and there was a framework that we can see from that RFQ. The framework provided 4 basic buckets of information. The first bucket was the process and approach analysis. The second bucket was a description and a narrative of your qualifications and experience. The third bucket was the staffing plan addendum. And finally, the 4th bucket was your cost proposal. So that was the required information that Metro asked each of those 6 respondents to provide to them. We'll go to the next page. Metro also reserved some of its rights. And I think this is important here because we have a reservation of rights versus requirements. Metro reserved the right to use consensus scoring. It reserved the right to make multiple awards if that was necessary. It reserved the right to ask questions in a written form or to do follow-up interviews. I think we have to focus on what the RFQ says because there's an assumption that CHS keeps repeating that there was going to be an interview. But if you look at this RFQ, it is not contained therein. There is no section of this RFQ that required Metro to do interviews with any of the responding parties. Rather, as we're going to discuss, Metro merely reserved its right under both Tennessee law and the Metro Code to ask follow-up questions. So when we go into this respective RFQ and what it says, it was 15 pages for qualifications, for process, 10 pages for qualifications, a staffing plan, and your cost proposal. On the document itself, that is all you were going to be able to submit. Nothing else was guaranteed. And so for CHS to say that it was their expectation or assumption, it was merely that. It was an assumption. And if they believed, as they now articulate numerous times in their briefs to this body, that 15 and 10 was merely insufficient without a guaranteed interview, as the purchasing agent said, that's a challenge to the framework. That's a challenge to the framework that should have been protested at the inception, not after the fact. All right. So after that framework is done, information is received, and ultimately what happens is Vital Core wins. And VitalCore wins by actually a notable margin, as we can see. They received 92.03 points out of 100. Now, CHS had an overall good proposal. It received 83.66 points. And ultimately, that's just not enough. Out of the technical score, which I'm going to lump together the process and qualification and just call that the technical score, there were 65 points. VitalCore got 60 of those points. CHS got 53. And as we look at these technical scores, you can see that the evaluation committee knew how to score a good proposal, such as VitalCore, an adequate proposal, such as CHS, and proposals that they deemed not satisfactory, like, for example, with first-class healthcare that received only 17 points. And I tell you, if you actually read that, you'll see track changes in the actual first-class report, asking questions. So it was an incomplete report, and that's reflected in the respective score. And that's what we would expect for people that had 100 years of collective experience on providing these respective services on the evaluation committee. If we'll go to the next slide, this merely just outlines the timeline, which has been talked about pretty in depth. So I'm just going to say we're going to move to the next page. There were 7 points that the purchasing agent talked about that were presented to him. But as we sit here today and look at the brief submitted by CHS, those appeal points have been distilled down to effectively, we can go to three areas, which is the RFQ procedure was not fair, and we suffered prejudice. That's what CHS argues. The scoring was arbitrary, and there was confusion regarding a required contractor. Those are the 3 points you've really heard about in their respective brief and heard about here today. Let's talk about the rebuttal to those points. Let's go to the next page. Metro followed the rules of procurement. They did what they said they were going to do. 15 pages, 10 pages, we reserve the right to ask follow-up questions. It's not prejudicial to conform with law and to follow the rules of procurement. It's actually the reverse that usually brings us here. When someone says, we're going to do something, but we then do not follow the rules of procurement, that usually gets a purchasing agent in trouble because it's arbitrary not to have everyone follow the same respective rules. That didn't occur. Second, and with all due respect, there's just no basis to pierce the scoring here. I frankly still don't understand CHS's argument. Consensus scoring is allowed. The evaluation committee came up with respective numbers, and they sit here today and say, how can we trust those numbers? Well, with all due respect and candor, you'll find nothing tethered in fact or law that allows that question to be asked without any kind of evidence of bias or prejudice against CHS, for which none has been offered. And finally, regarding the mental health cooperative as a required subcontractor, with all due candor, it does not say that in the RFQ. It provides nowhere that this was a required subcontractor, rather that there had to be a memorandum of understanding, and that memorandum of understanding is appropriate here because there is a transition of care, there's a transition of patient information, and multiple entities outside of Davidson County interact with this patient population. And thus having memorandum of understandings on how to transition PHI to those respective entities is important. But notably, nowhere is it required that the mental health cooperative be a subcontractor to the behavioral care center. All right, so let's talk about the first point here. It's not prejudicial to follow the rules of procurement. And that's what we want you to take away from today. It's simply not prejudicial to do what you said you were going to do. And so when we listen to what CHS, we'll go to the next page, is arguing, is it was problematic to follow the disclosed page limits. And it's problematic not to permit us to change the rules after the fact, after the award has been done, to guarantee an interview when no interview was going to be given. So let's start with the basic point that the purchasing agent made. This is a challenge to process, not analysis. This is a challenge to the process, and this process was articulated well before any submission was given. If CHS believed that this was only going to be a 60-second trailer analysis, as they say, they should have spoke up. They should have spoke up at a pre-bid objection, but that didn't occur here. VitalCorps spoke up in the question and answers. VitalCorps was actually the entity that asked for more pages, and 5 more additional pages were given. So everyone knew the rules of the road before they made their respective submissions. And everyone knew that it was only a reservation of Metro to ask follow-up questions. CHS makes a lot to do about this departing from normal course, but respectfully, there is no scored interview in the scoring matrix here. There is nothing to indicate in this RFQ that you would be given any additional opportunity to submit any additional information after the written proposal was submitted, after those 4 buckets of information were given. So to now come here and challenge that today is simply too late. The next, they do talk about interviews. And I think I can just say this shortly. It's not required. CHS has conceded that point, and that's a quote from their brief, although not required. See, they hid grammatically what was not required, so you maybe not caught it, but actually what they mean is interviews are not required, either under Tennessee law or the municipal code. So they pivot, and they say, well, follow-up questions, if we go to the next page, were asked of VitalCorps. And that's correct. That is a fact here. 4 discrete follow-up questions were asked, and both under the Metro Code and Tennessee law, that is permitted. And again, that's also permitted under the RFQ. That was their respective right, Metro's right, that is, to ask clarifying questions. The fact that Metro did not ask or did not deem it appropriate to ask clarifying questions is within their prerogative when it comes to CHS's respective submission. Now let's take their argument to the logical, or rather in this case, illogical conclusion. We know that under these 2 respective sets of laws, the purchasing agent or the solicitation coordinator can ask follow-up questions. In any case, if you accept CHS argument that the solicitation coordinator asks one respondent a follow-up question, now there is a basis to appeal every award if that solicitation coordinator did not ask every respondent some other type of question. That's not what's required. What's required under this law is that if you actually pulled them in and did an interview outside where they could explain their entire process and approach in an hour interview, yes, that would be arbitrary. And that would be fundamentally unfair because that would be giving one respondent an opportunity that you didn't give the others. But that did not happen here. These are merely clarifying questions. And that's permitted by both law and by the RFQ. The next argument that Vital or CHS advances is this lack of detailed commentary. And they make a lot of the written commentary within the score sheet. Well, let's start first that this written commentary is not even necessary. We don't know where it comes from, but it's not necessary. And there is no correlation that can be judged about the written commentary to the actual written score. And again, we come back to piercing the score and substituting the judgment of CHS versus VitalCorps, or the scoring committee, excuse me. If you look at the original brief that was filed, the CHS was actually bold to say, if you look at the commentary, we should have gotten more points. They're not making that argument today. They've abandoned it because it was just ridiculous. But if we look at the areas of critique, they identify 42 areas of all 6 proposals for which there was a concern of lack of detail or vagueness or some species of that type of critique. In this case, CHS only had 4 of those critiques, VitalCorps 3. Notably, each of those entities are the respective authors of their proposal. They knew they had only 15 pages. And if you look at the respective proposals, you'll see that CHS used nice graphics, used photos, and used negative space to make an emphasis on certain points. That was their choice. Comparatively, VitalCorps, it's just a narrative. It is 15 pages of pure, dense narrative. It is not as pretty. I'll concede that. But that was not the goal here. This is not a show horse presentation. It is about information. Most importantly, if you look at the commentary, if you do want to do so, they noted, the evaluation committee, that CHS failed to provide information about responsibilities of sub-level providers. So there's actually not lack of detail, there's a failure to provide information. So this evaluation committee, with all of their respective experience, judged these actual narratives and determined that VitalCore got 29 out of 30 points. Let that sink in. 29 out of 30 points. There's no way to ascertain that this was arbitrary or capricious. That was their evaluation. And that leads to the next point, that the scoring was arbitrary. Now, I think it's helpful here to help understand what arbitrary is, at least under Tennessee law. So we've got a quote here, if you go to the next page, that arbitrariness is basically not based on any course of reasoning or the exercise of judgment and disregards the facts and circumstances of the case. So they want you to believe that the evaluation committee, that are subject matter experts with over 100 years of experience, completely disregarded their own judgment and used no reasoning, coming to the conclusions they reached today. That's a bold statement to make. If I was in front of the Chief Procurement Officer for the state of Tennessee, Michael Perry, or in front of the State Procurement Board, I would be hamstrung by Tennessee Code 123514 in 2A. And that's a provision that provides that if I'm going to challenge an evaluator's score, I have to show some type of bias or prejudice. Now, I know that Metro doesn't have a corollary, but I think that guides our discussion today on what is arbitrary and whether there's any type of entitlement under the law or the rules of this procurement to ask to interview the evaluators, to ask them questions, and there's simply not. So what you have here is just a bald accusation that the evaluators were arbitrary, that they disregarded their 100 years of experience, and that for no reason at all, they awarded 29 points out of 30 to VitalCore and only gave 23 or so to CHS. That's not the case. And when you look at the fact that we have 6 respondents, and some responses were given a 7 as compared to a 29, we know from that disparity that the evaluators knew how to judge a poor submission versus a good submission. Maybe CHS's argument would have more traction if the overall scores were between 7 and 10 points out of 30, because that may be indicative of not having sufficient pages to articulate how you are going to provide the respective care, but that's not the factual scenario we find ourselves in. What they're asking for you to do is just to disregard the 29 out of 30 score for VitalCore and say that this was all arbitrary and that if we would have had more pages, our score would have been better. They're asking you to take the blame off of their shoulders and put it on someone else's. They are the author of their presentation, just as was VitalCore. So the final point we're going to discuss today is that, respectfully, there just was no confusion regarding the mental health cooperative as a required contractor. First off, we have to start with the RFQ. The RFQ provides in no section that the mental health cooperative was a required contractor. It's not there. Page 7 of the RFQ discusses the need to enter into an MOU with several agencies, including the mental health cooperative. But nowhere does it provide that the mental health cooperative was required to be the subcontractor, particularly for the behavioral care center where it currently operates. Go to the next slide. I think an important point that is omitted here is, again, 6 respondents. 4 out of 6, the majority, did not use the mental health cooperative as the required or as a subcontractor to provide mental health services.
You have 2 minutes.
Behavioral care center. Thank you. That is telling. The only 2 that did was the incumbent, who currently uses the mental health cooperative, and CHS. CHS asks you that because they did interviews with what they perceive to be the stakeholders, that those ex parte interviews can now change the rules of the RFQ and create confusion when there was no confusion. CHS, again, made a choice. They made a choice to use the mental health cooperative as their subcontractor, and that inflated their respective costs. There is no confusion about what was required and not required. Again, this is CHS's choice. Just where they made a choice of what to put in their actual proposal, they made a choice to use the mental health cooperative. It is not the responsibility of Metro or this body to find a justification to alleviate them from the responsibilities of their respective choices. To do so would actually change the rules of procurement to find a way for CHS to have a second bite of the apple. And frankly, I believe that would be arbitrary and contrary to law. So as we wrap up here are the objective facts we know. Vital Core received the highest technical score and had the second lowest cost proposal. That's a rare situation where you have the highest qualified rated entity providing a low cost evaluation for the services. And you know what that is? That's a recipe to win competitive bids in any government procurement. And that's what occurred here. CHS has failed to demonstrate that this procurement was done in violations of the rules of procurement or Tennessee law. They waited too long to protest the framework, and they've provided no factual basis nor legal basis for this body to disturb the purchasing agent's decision. Both the purchasing agent's decision and the evaluation committee was well reasoned, and we ask that it be affirmed. Thank you.
Thank you, Mr. King. We will now have a 5-minute break. I show around 10:18, so we'll just go ahead and make it a nice round number and be back at 10:25 a.m. to restart. The restrooms, as I said, are out this door to my left. We'll see you at 10:25. The next item on the agenda is the second presentation by the purchasing agent. Please be reminded there is a 15-minute limit to this presentation. Please reintroduce yourself and any others who may have joined you.
Okay, thank you, Chair Potter. As the purchasing agent, I'm very respectful of the decision that will be made by the Procurement Appeals Board. As I mentioned earlier, this is an important part of the procurement process. Based upon the facts, Metro did not make a mistake in this solicitation. Our team feels confident we have selected the very best solution to meet the department needs and the inmates' needs. Our process was fair to all parties. Metro Procurement did exactly what we said we were going to do in the solicitation process. Metro's cross-functional team of experts clearly understands all of Mr. Carr's key points. They do this for a living. Honestly speaking, it is offensive that he comes in to present that we do not understand what we're doing. I think it's important to give an example of vagueness, since vagueness seems to come up a lot in the CHS comments. When requested basically about company violations, CHS stated they were not aware of any company violations. So from my perspective, you would think that if you're presenting this in your solicitations, you would check that and actually respond appropriately. There's no requirement in the regulations for oral interviews. This is usually covered by amending the solicitation and adding another round of demos and additional questions and answers. If we were going to interview 4 points, we would need to disclose this to all parties. The deficiency of the CHS proposal was evident. We simply found as a team that they did not bring the strongest proposal to Metro, thus the scoring of what they received. Regarding Vital Core's questions, I will allow the board to decide whether they were clarifying in nature. From a Metro procurement perspective, in our discussions with legal, we think they are clarifying, but we respect the board's decision in regard to that. I think it's important to note, and I think Attorney Rocky actually mentioned that there was only one other supplier who quoted the use of MHC in the bids. So apparently there was some level of clarity in understanding the point that was actually requested in the solicitation. Based upon the facts that have been presented, based upon the discussions, I now concede the additional amount of my time, and we'll actually give it back to you, Chair Potter.
Thank you, Mr. Rowland. The next item on the agenda is a second presentation by the appealing party. Please be reminded there is a 15-minute limit to the presentation. The appealing party's representation can proceed.
Thank you. Michael Catone, Holland tonight, here today on behalf of CHS. I want to jump right into something that the purchasing agent said. I want to clarify something. We're not saying anyone here is a bad actor, that anyone involved in this did something intentionally wrong. We understand Metro has vast procurement needs, right? It's a hard job. We appreciate and respect the work that the procurement team does. We're also not trying to substitute, CHS is not trying to substitute its judgment for the evaluator's judgment. If we were trying to do that, we would say, no, award the contract to CHS. What we're saying is that the process did not live up to what was required in this particular instance. That's rare, but it sometimes happens, especially when, as the purchasing agent said in his initial presentation, there's 100 to 150 open procurements on any given day, right? Sometimes mistakes happen. And it's this board's role to step in when they do happen and to fix them. That's what this board's role is. There's a reason this board doesn't meet very often. Most of the time, the process works exactly as it's supposed to. But here we have a pretty unusual circumstance. We have a $150 million contract for the provision of complex health and mental care at our city's jail. And that contract was awarded on the basis of a 15-page description of how that contract is to be performed. Without any oral presentation, and where the only follow-up questions asked to anyone were asked to the winning bidder. And if you look at the evaluation comments, we have another circumstance here that's unusual. We know that the evaluators based their decision primarily on a lack of information. That was the most common comment in the evaluators' comments, that there wasn't enough detail, that something was vague, that they lacked information that they needed. That's not a process. That's an arbitrary process for a contract of this kind. It's an arbitrary process for a contract of this kind. I want to make clear, because I think this has gotten jumbled up and lost in the mix here a little bit. CHS is not saying the 15-page limitation was wrong on its own, right? The page limits could have been fine if oral presentations were held, as would have been typical for a contract of this size. That could have been fine. If follow-up questions were asked to everybody and the evaluators got all the information they needed, that could have been fine. But what we know is that the evaluators clearly had outstanding questions in many areas. Over half of the evaluation was based on lack of detail, vagueness in the comments. With oral presentations, that could have been answered. They could have got the information that they needed. CHS did not know oral presentations would not happen until it received the notice of intent to award, right? There's been some talk about that. The RFQ clearly states that oral presentations may have occurred, and you would expect them to occur if evaluators are basing their decision on the fact that they don't have all the information that they need. You would expect, and I would say to make the process not be arbitrary, it would be required that oral presentations would be held under those circumstances. CHS appealed at its earliest opportunity after it found out that, no, we're going to be judged on 15 pages with no opportunity for additional comment. And the bottom line on that is, when the evaluation process for a complex $150 million contract is based on 15-page descriptions, and the award is based primarily on a lack of information, it's necessarily arbitrary. It's necessarily arbitrary in that circumstance. Now, in its presentation, Vital Core says that CHS assumed that there would be follow-up questions or oral interviews. Well, the fact is that there were follow-up questions. It was just that CHS wasn't asked any of them. That only Vital Core was asked follow-up questions, right? And the fact that Vital Core was the only bidding party to be asked follow-up questions means that the process violates Metro's own procurement rules, right? Everybody's, to some extent, trying to dance around that, but I think it's crystal clear that that's true. Vital Core was asked 4 follow-up questions, and those questions, maybe they were yes or no questions, but what happened is that Vital Core gave 4 full single pages of responses, right? On top of a 15-page limitation on how the contract was to be performed, they gave 4 additional pages. That's an enormous amount of additional information that Vital Core submitted in response to those follow-up questions. And again, no one else was given that opportunity. No one. That inherently violates section 4.12040F of the Procurement Code, which provides that offerers shall be accorded fair and equal treatment with respect to any opportunity for discussion and revisions of proposals. The procurement regulations in 4.12.040.14.2 say the same thing. Now, we've heard the purchasing agent say, well, the reason we only asked Vital Core is because at that point we had ruled CHS out. Well, that doesn't hold up. This is the first time we've heard that statement, is sitting here in the room. And that does not hold up to what actually happened. CHS was the second highest bidder. The second highest bidder. And as you heard Vital Core's counsel say itself, it was a good bid. It was a good bid. So to say that, well, we just don't think it was good enough to ask them follow-up questions, frankly, that doesn't hold any water. That violates the procurement code. That violates the procurement code. Now, in the original decision, the purchasing agent had said that the regulations allow for discussions that promote the understanding of the offeror's proposal. And I want to make something clear about that. No one is saying that the evaluators, the procurement team could not ask follow-up questions at all. What we're saying is that if you're going to ask follow-up questions, you have to give everyone the same opportunity. You have to give everyone the same opportunity, because otherwise you get an unfair situation where the winning bidder is allowed to submit 4 single-spaced additional pages of information. It should come as no surprise that that was the winning bid at that point, because it got a substantial amount of additional information in a bidding environment where the decision was made largely based on a lack of information or a lack of detail. There was also some discussion about whether or not these questions could have affected the outcome. I mean, they certainly could have, right? The information that Vital Core provided dealt with process and approach, and it also dealt with qualifications and experience. Those items tied directly to things that ultimately ended up as positives in Vital Core's evaluation, in the comments in Vital Core's evaluation, especially with regard to the evaluation team's comment that Vital Core provided a detailed response to team's knowledge and project experience and the provision of services related to the project. Vital Core provided a lot of information in those additional 4 pages regarding qualifications and experience. And so that's an additional 6 points for qualifications and experience, an additional 5+ points on project process and approach that could have been awarded, which is well more than enough to bridge the gap between the 2 proposals. If there is any question about whether those issues are outcome determinative, they're resolved by looking at cost, right? That's another 5+ points CHS could have been awarded. And the only reason that CHS's cost was above Vital Core's was because CHS included in its proposal MHC, providing mental health services. Had CHS based its pricing on providing those services itself, its cost would have been $8 million less. Now, in the process, CHS was told, in the initial discussions regarding the bid, it was told that it was important for MHC to remain in place. And the RFQ itself indicates that whoever the bidder was had to enter an MOU with MHC, right? Now, we've heard some explanations, some after-the-fact explanations that that's a MOU for transition. The RFQ doesn't say that. And frankly, that doesn't really stand up to some scrutiny, because if the purpose of those MOUs was for transition, then the RFQ would have said that the winning bidder, if it wasn't the incumbent, was required to enter an MOU to transition services with the incumbent provider, not just for mental health services, but for all of the health services, the owner of the PHI, right? If that MOU was about transition services, you would have seen that requirement in the RFQ too, but it's not there. The only reasonable explanation for having an MOU requirement in the RFQ is that you expect MHC to continue to be providing the services. Certainly, that's the reasonable takeaway reading the RFQ if you're CHS. Nothing else really makes sense. There's nothing that would have indicated that was a MOU for transitions. In fact, every indication's to the opposite. I want to end where we started in our initial presentation. I want to look at the three purposes of the Procurement Code. The first purpose is to provide for increased public confidence in the procedures followed in public procurement. If the public learned that a contract involving the expenditure of $150 million in taxpayer money was awarded on the basis of 15 pages of description of how the work was to be performed, with no oral interviews and evaluator comments that make clear that the decision was based on a lack of information rather than on information that they had, would the public be confident in that process? I think the answer to that's no. Would the public be confident in a process where, in addition to those things, the winning bidder was asked follow-up questions,
2 minutes.
but no one else was? No, I don't think the public would be confident in that process in this particular instance. The second purpose of the Procurement Code is to ensure the fair and equitable treatment of all persons who deal with the Metro procurement system. In this case, it's clear CHS was not treated fairly and equitably because it wasn't given the same opportunity to provide responses to comments, to provide information to the evaluators as the winning bidder was. That's in violation of Metro's Procurement Code, and it violates the principle that all people dealing with the procurement system should be treated fairly and equitably. And the third purpose is to provide safeguards for the maintenance of a procurement system of quality and integrity, and that's where this board comes in. This board's the safeguard, right? We have to make sure that the problems in this procurement process are fixed while this is still in Metro's hands. So we ask that the board reverse the purchasing agent's decision, cancel the intent to award the contract to Vital Core so that the bidding process can be redone in a fair manner. Thank you all for your time and consideration today.
Thank you, sir. The next item on the agenda is an additional break. I'll ask the board if y'all want a break or not. Okay, so we will continue with the agenda. So the next item on the agenda is discussion and deliberation by the Procurement Appeals Board. Board members are encouraged to ask any question that will provide clarification to comments made by the purchasing agent, the appealing party, and any interested party. I'd like to remind everybody that outside the board, you need to be recognized by the chair to provide commentary or answer questions. So I'll ask the members of the board if they have any questions that they would like to present.
I have a question. So what's your position, Doug, is that right? Dennis, sorry, I got the D right. What is your position on when it is fair and equal treatment to provide only one finalist in the top of the range with a follow-up question when you don't have the answer to that question from either of the two top finalists in the range? Is there ever a circumstance where that is considered fair and equal treatment?
So all solicitations are unique, right? And so it's actually on. Sorry. So in the case of clarifying questions, all the proposals are unique. So it really, from a logic perspective, doesn't make sense to ask the same question to all since all the proposals are different. So in all cases, the goal is to follow the law, follow regulations, follow the code. So the code doesn't state that I have to ask the same question to all parties. It doesn't state that if I ask a clarifying question, I have to go and find some other question. Just to be honest with you, on the CHS proposal, there was not enough information there in some cases to even ask clarifying questions. And so I think I'm speaking on behalf of the evaluation. We have some of the evaluators in the room today. That was the information that I received in the reason why there were clarifying questions asked to one and not asked to all.
Okay, so just to make sure I'm understanding. So let's say one applicant so a clarifying question, you're allowed to ask a clarifying question if there's information pertaining to that. So in an application that doesn't have any information that you asked on the clarifying question, you can't ask it to the other group because it's not clarifying because they didn't have anything to begin with? Or are you allowed to ask a clarifying question that isn't really clarifying anything in terms of their application except the lack of information? Did that make sense?
Yeah.
Okay.
So, I mean, we could very easily have asked all suppliers those same 4 questions. I mean, but in some cases, it would not make sense to the other suppliers because the proposals are all different. And that's, I like the fact that the request for proposal process gives you ability to ask questions. It gives CHS and the suppliers the ability to ask us questions back, right? And in this process, and just so that we're clear, the Q&A between is enormous. There's an enormous responsibility to procurement and to the departments in asking, basically answering the questions that come forward. In this case, there were over 400 question and answers that went back and forth. So there are a lot of information is going back and forth related from actually all parties.
So you are allowed to ask a clarifying question to an applicant that has provided no information on that topic?
We could very easily have asked.
Okay, so what would be the reason for not wanting to ask a clarifying question on something that you expected, a service you expected them to provide that they provided no information on? If an applicant provided no information on it, what would be the reason from a procurement perspective to not follow up on that when it is still an expectation of the service provider?
So in my mind, you get into a fairness issue because I'm sort of leading the supplier to the answer that we're expecting rather than them providing the answer in their proposal. Does that make sense? Did I answer your question? I'm sorry.
So it doesn't seem fair when you have no information because it would seem like you're leading them
Correct.
to what you want.
Absolutely.
Ms. Lance, do you have any further questions?
Yeah.
Okay, we'll keep you going.
You said you were told it was important for MHC to remain in place. I missed that somewhere. Can you tell me where you were told that?
So it was part of the due diligence when they were talking to the departments and trying to decide whether they wanted to submit a proposal. And so
Okay.
it was not actually part of the RFQ. It was pre-RFQ.
Okay. And why do you think that the other applicants knew not to include MHC if they didn't want to, and you all didn't know that?
We don't know what level of conversations they had with the departments in advance. All we know is the conversations that we had and the understanding that we had of the importance of mental health cooperative and their continuation as the provider.
Okay. I said 2 more. They're really fast.
Have at it.
Okay. Could they have objected when you raised it to the 15-page limit? Was there a time frame for them to say, we think it should be more?
Absolutely.
Okay. And then what is your response to their point that the score wouldn't have just gone up in qualifications and experience, but also, wouldn't have just gone up in project process and approach, but also in the qualification and experience section?
So from the evaluation process, each individual area is scored differently. And so that would actually, if there had been a consideration or something that we need to adjust or make an amendment to, that would have actually been rescored appropriately. But in this case, like I said, from our perspective, the proposal just didn't have enough information in it for us to score it the way we did.
But they're saying that their score would have gone up in the qualification and experience section as well, because if they had provided that information, some of it would have been in that section too. Are you disagreeing that that score would have gone up? Okay, is that a possibility?
I would like to, the evaluators would have to be the ones to assess that,
Okay.
but I think for me, that's an assumption.
The answer is no.
I'm sorry, the answer is what?
No, that would be no.
That's not a possibility.
Correct.
Okay. Do you all have a response to that?
The response I would say is that they could have asked clarifying questions on any topic, right? They were not limited to process and approach on the clarifying questions they would have asked.
I'm just asking, they said the answer was no.
I think the information in Vital Corps' response very clearly went both to process and approach and to qualifications and experience.
Thank you.
Mr. Rich, do you have any questions?
She basically, Diane basically covered every question I had. The only one that I have is all the applicants could ask any questions that they had before they submitted the information, correct?
So that's sort of the importance of going through the entire process from start to finish, is there were dates and times, pre-offer meetings, where usually in pre-offer meetings, no questions and answers are discussed. We actually encourage them to bring their questions after the pre-offer, but there's an entire process that we go through in order to get questions and answers. So honestly speaking, our goal in our procurement process is to get all of this out earlier in the process to where it's clear to everyone. We don't want to waste anyone's time. And we want it to be an efficient process, not only for Metro, but we also want it to be an efficient process for the departments and our supply base.
Mr. Rich?
Recognized.
I was just referencing.
I think-
Sorry.
It's the purchasing agent, so if the board has questions, they have to determine who they ask questions of.
I would like to be recognized.
Okay, please proceed. Please identify yourself first,
I am
please.
Sandra Walker. I'm with Metro Procurement. I can tell you we did a pre-offer meeting. I believe it was on a Tuesday. We did the walkthrough through all facilities the following day. It was an all-day event. Vendors did ask questions, but we reminded them in the pre-offer, as with the walkthroughs, any question must be submitted in writing to get an official answer from Metro. There were some questions that were answered, but I made sure to remind the vendors present it was not the official answer. It had to be submitted in writing, and we've had the most. We had like 427 questions on this solicitation, so vendors had ample time to submit any and every question, and they did. Thank you.
Did you receive any other questions about the MOU portion with the various agencies and departments from the other applicants that you recall?
I can't recall out of the 400 questions. I'm sure there were, but the MOU was a requirement. It was not an evaluative item. So vendors were not required to submit an MOU and then to be evaluated. If you were the contract, you would have to have the discussion and contract negotiation how to follow through on that requirement of the solicitation.
I just didn't know if there's any other questions from the other applicants pertaining to if they had to enter into an agreement MOU with MHC or not. So that's why I was kind of getting at that. So, okay, thanks.
Mr. Rich, anything further?
No, sir.
Mr. Smith?
Well, they've kind of stole the thunder here. The only question that I guess I really had, maybe I didn't, I think I heard the comments to it, and that was MHC and so on, and that was an option. Is that what I understand in terms of, or was it mandatory that they contract with MSC for the mental health care services?
It was a requirement in the solicitation that if you were award this contract, you would have to have policies in place to have a memorandum of understanding to keep providing these services, but we did not specify a certain vendor you had to have the contract with. If you award this contract, those services would need to be provided. It was just an understanding that if you award the contract, these services would continue. We didn't specify with what company. The evaluation criteria did not have you had to submit an MOU. It was not something we were scoring vendors on.
Thank you.
Mr. Smith, are you concluded with your questions? Okay, thank you. I have a question for Mr. Rowland. Is it the purchasing agent's position that the process for the procurement was clearly communicated to all interested parties?
Yes.
Okay. I want to make sure I don't have anything else I wanted to ask. And it's the purchasing agent's position that the scoring was done in accordance with procurement regulation?
Yes.
Okay. So, Nikki, I have one question as to process. This is my first time as chair. Am I a voting member or not?
Yes, every member votes. Every member can make a motion. Any member can second on it. Every member is entitled to vote.
Okay, thank you. So now, Nikki, please remind the board as to the board's options going forward.
Sure. So, tracking the language of the procurement code, the role of the board is to determine whether the award was done in accordance with applicable law and the terms and conditions of the solicitation. So applicable law will include the Constitution, the statutes, Tennessee statutes, procurement code, and procurement regulation. If the board determines that the award was in accordance with applicable law and terms and conditions of the solicitation, the board can uphold the decision of the purchasing agent. If the board determines that the award was not in accordance with applicable law or the terms and conditions of the solicitation, the board can modify the decision of the purchasing agent and remand the matter to the purchasing agent with further directions. So one thing I wanted to say, just to whatever motion the board makes, members make, is just to follow the language of the code, which is the code says, on any appeal, the board shall decide whether the solicitation or award was in accordance with the Constitution, statutes, this code, regulations, and the terms and conditions of the solicitation. So for clarity of the record, it will be helpful if the board's motion tracks the language of what this board is required to decide under the code.
So I'm going to ask members of the board if they have any questions about the instructions from the attorney to the board. Okay, hearing none. I'd like to request a motion from the members of the board.
Well, I would, if I can phrase this properly, I'm going to move that in support of the procurement officer's recommendation to award this bid to the current prevailing service provider in compliance with procurement rules and procedures.
Okay, understand. If I could, I'd like to rephrase that more succinctly. It's essentially, it's make a motion to uphold the decision of the procurement. Okay. All right, so I'll make that motion formally. I make a motion to uphold the decision of the purchasing agent. I'll request a second.
Second.
Okay, procedurally, I'm going to open up for discussion. The motion to the board. Any questions on the motion? Okay, hearing none, I'll ask for a vote. So we'll go down the table and register our vote for the record. I'm Scott Potter. My vote is yes.
Gerald Smith, my vote is yes.
Brady Rich, my vote is yes.
Diane Lance, my vote's yes.
So Nikki, what communications and documentation will be sent to the parties of the appeal hearing?
I will prepare an order that will be signed, and that order that memorializes your decision will be provided to all parties.
And Nikki, within what day period will that occur?
It should be in the next week. Under the rules, you have up to 30 days, but it should be in the next week.
Understood. Nikki, do you have any further business before the board?
No.
Hearing that, I will state that the business is concluded and that the meeting is adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.